Hello and welcome to Law Weekly on Channels Television. I am Shola Soyele. My guest on today's edition of the program is Mrs. Funke Adekoya, a senior advocate of Nigeria who has held different positions in the NBA. She's been former First Vice President, former National Treasurer, past Chairman, Section on Legal Practice, and past Chairman, Conference Planning Committee of the Lagos and Kaduna conferences. In a short while, I'll talk to her about the last elections of the NBA and some other issues in the news. But first, let's take a quick look at the top stories from the courts. On Monday, the 30th of July, the coroner of Alimosho district of Lagos State, Magistrate Oyetade Komolafe, will continue his inquest into the ill-fated Dana airline crash of the 3rd of June 2012, in which over 160 lives were lost at the Iju-Ishaga area. Last week, Thursday, the coroner issued a bench warrant to compel the attendance of Cornell PLC, Total Nigeria Limited, and the Red Cross Society of Nigeria. The inquest, which is a fact-finding one to unravel the cause of the airline crash, was at the instance of the law firm of Falano and Falano and Olisa Agbakoba and Associates, who wrote a petition to the Lagos State Chief Coroner, Justice Latifat Okunu, who subsequently directed Coroner Magistrate Oyetade Komolafe to inquire into the incident. The coroner had summoned certain oil firms and agencies of government to appear before it to help with its inquest. The bench warrant was issued after a schedule of appearance was fixed, and some parties to the inquest failed to appear. A federal high court sitting in Abuja last week Tuesday granted Senator Ali Ndume permission to travel to Saudi Arabia to perform the Lesser Hajj. The senator is facing charges for allegedly sponsoring the activities of Boko Haram. Before this leave to travel to Saudi Arabia was granted, his move a few months ago to travel for a Millennium Development Goal Conference was quashed by immigration officials. Justice Gabriel Kolawole, who is hearing his case, noted that the prosecution has not proven with any facts why allowing the lawmaker to leave the country will prejudice the case before the courts. Senator Ndume was therefore allowed to leave the country from the 1st of August to return on or before the 31st of the same month. Upon his return, he is to deposit his travel documents with the Deputy Registrar of the court for verification. Staying in Abuja, the same Justice Gabriel Kolawole granted an ex parte interim order for fixing to the federal government $15 million said to have been received by the EFCC from an undisclosed agent of former Delta State Governor James Ibori in 2007 as a bribe to compromise his investigation. The money is said to have been kept in the strong room of the Central Bank of Nigeria as an unclaimed property since August 2007. Justice Gabriel Kolawole noted that former Governor Ibori had denied ownership of the money, and he therefore upheld the federal government's claim that the said money, if left untouched and unspent in the state it was kept in the strong room since April 2007, may eventually be destroyed, defaced, mutilated, and become useless. The interim order is to be published in the national dailies for anyone who is interested in the money to show cause within 14 days, while the final forfeiture order should not be made in favor of the federal government. Hearing of the final forfeiture order has been fixed for the 17th of September. "24 hours after docking the first batch of fuel subsidy suspects, the Economic and Financial Crimes Commission, EFCC, finally got round to arraigning some of them, despite the absence of the Attorney General of the Federation, Mr. Mohammed Adoke Bello, who was initially scheduled to lead the prosecution. Former PDP National Chairman Amadu Ali's son, Maman Nasir Ali, was one of those arraigned before Justice Adeniyi Onigbanjo. Mahmood Tuko, the son of the present PDP National Chairman, Alhaji Bamanga Tuko, was also arraigned. They were charged along with their companies and some others for obtaining subsidy funds for purchase and importation of PMS under false pretenses. The two men were granted bail in the sum of 20 million naira each, with two sureties in like sum. It's not certain if they've met all the bail conditions, but Abdullahi Alao, the son of Ibadan businessman Arishekola Alao, who was also granted bail, would however not be going home yet, as another judge, Justice Abibabiru, is yet to determine his bail application on similar charges. Further hearing in that case has been fixed for Wednesday, the 1st of August. For Mrs. Adawa Ugo Ngadi, Ontario Oil and Gas Nigeria Limited, and 3 others who are yet to be arraigned, they will also remain in the custody of the EFCC, pending the appearance of their co-defendant, Walter Wabasoma, who is scheduled to return from a trip abroad on Monday for a date with the court on Wednesday, the 1st of August.
You see, life has just got easier. You stay connected to Channels TV, where news and innovations are shaping our world. Simply log on to channelstv.com to get the breaking news. Browse the homepage according to what matters to you. Tap on the extended coverage of business, sports, politics, lifestyle, infotech, entertainment, health, world news, and lots more. Click on the live link and see the news in real time. Do you want to watch the latest video of the day? It's just a click away. Friend us on Facebook, YouTube, follow us on Twitter, Google+, participate in Channels TV poll and share your comments. It's a website you can talk to. Your voice will be heard.
ChannelsTV.com. The news at your fingertips.
Welcome back. Joining me on the program now is Mrs. Funke Adekoya, Senior Advocate of Nigeria, who's practiced law for about 35 years. Let me start by getting your assessment of the last elections of the Nigerian Bar Association. There's been allegations of rigging and so many fallouts, so many reactions. What do you make of the electoral process?
I don't think the elections were rigged. That's my personal view. I think Okewale, the candidate who won, I think he deserved to win. He put a lot of hard work into it. I think Emeka Ngige was a worthy opponent. And I think he would have made a good president. But I think possibly he hadn't been in the race as long as the person who won. That's one. And secondly, I think we ought not to discount the zonal politics that went into it, both inside the Eastern Bar Forum and the other zones. So I don't think it was rigged. We all heard allegations of horse trading, of inducement of delegates. I didn't see any, but I think the allegations are weighty enough for the new president to look at the NBA electoral system all over again.
A lot of people are curious, and you've been first vice president. What is it about the office of president of the NBA that, you know, there's so much attached to it? When I get there, I'll tell you.
But I really don't know. It's an opportunity to lead the profession and to do good. Now, whether that opportunity has been fully utilized by the incumbents is something that posterity will judge. There has been so much pressure, people struggling to become the NBA president. I really can't say other than the opportunities that are available in respect of the profession. It's also a prestigious role because you are the leader of one of the foremost professions in the country, and you have onerous responsibilities to uphold the rule of law, to be the voice of the voiceless, to direct and guide the profession in the way it ought to go. And maybe that's one of the reasons why people put a lot of pressure towards getting there. I don't think that should be how we should continue, especially in the 21st century.
Okay, we're talking about how we should continue. I'm going to ask you questions about that. But one of the things that some people also said to me as a result of the elections, the fallout from the elections, was that because in this delegate conference system, voting, it disenfranchises some people no matter how you look at it.
And it not only disenfranchises some people, it disenfranchises the majority of the profession.
Yeah.
I think personally it has actually resulted in a disconnect between the profession and the association, because a lot of people can't vote, don't vote. The manner in which delegates are appointed is less than transparent. And I think that's what we need to look at. I think the days of electronic voting are here. There's nothing that stops us from doing the same. And I think that's one of the things that we should be able to look at and go back to universal suffrage. And everybody has a stake in who becomes the president of the profession that leads them.
Mr. Dele, additional senior advocate of Nigeria, said to me that perhaps we're not yet ready for this system of electronic voting. What would happen in a situation where there's no electricity, there's no fuel to power the gens, that we're not quite ready, for electronic voting?
I'm currently the chairman of the Nigerian branch of the Chartered Institute of Arbitrators. Where the Nigerian branch, there are about 70 branches all over the world. And the head office in the UK has sent out emails to all the branch chairmen amending our model branch rules so that every branch by next year must elect its officers by electronic voting or postal ballot. And the argument is, if you're a branch member, if you're a member of the institute and you pay your dues, you must have the opportunity to vote for your branch chair and your branch executive. And it's not a question of the 50 people who can gather in Lagos and vote. And we have over 1,000 members. So next year, Lagos, the Nigerian branch, we're doing electronic voting. It's possible. Light is not an issue because we have generators. Illiteracy of lawyers or of people is not an issue because it's a question of taking one computer and one generator to one location in the state and saying, on this particular day, all the lawyers within that state come here, access the computer, enter your vote. There's something called evote.com. If you go online and look at it, you see how electronic voting works. It's simple.
Those who have advocated electronic voting for me, because you've given a different view of it, some of them even say, why can't we sit in our offices and we get something like we're filling a poll and we just vote, everybody votes in their offices, even asking people to go to a location.
That is electronic voting.
Okay.
But to take account of some states where perhaps, as they say, electricity is a problem, then you might then say, okay, fine, organize it on a branch by branch basis.
Okay.
And on a particular day, everybody goes to a particular location within the branch, access the computer, and vote.
So that's something that you would commend to the incoming exco.
I'm not only commending it to them. I'm asking that the members of the legal profession, who are members of the Chartered Institute of Arbitrators, when we've done it next year, April, go and tell people that that's how it's done.
The controversies that followed the conduct of these elections, especially the policy of zoning and adoption in the NBA, is it necessary?
I think you know my answer to that. I don't think it is proper, because in 2006 I contested and I was from the wrong zone. And at that time it was, oh, you're a fantastic person, but it's not your turn. You're from the wrong zone. I think that it is good to have some sort of convention that allows everybody to feel included and have the opportunity. But the way we have moved this zoning, now people are talking about, you have zoned the presidency, you are zoning general secretary, you must zone assistant secretary, you must zone publicity secretary. You start to think of sharing political spoils. And I don't think that is what service in the Bar Association is all about. So whilst I agree that we must have leaders of groupings within the country, and those groupings are not just ethnic, they're religious groupings, they're cultural groupings, they're young lawyer groupings, they're business lawyer groupings, and I think all those groupings need to be acknowledged. In other countries, you have a national executive where you have a particular number of seats for lawyers 10 years and below. You have a particular number of seats for women. You have a particular number of seats for sole practitioners. So countries recognize that within their profession, there are diverse groups. I think we need to recognize that as well. But to elevate it to a level where these groupings then sit down and dictate who gets what distracts attention from the fact that these offices are opportunities to serve and nothing more than that.
Because when you look at the composition of the incoming exco now, it seems like the Eastern Bar took the shine. They mobilized, or I don't know what it was they did, but almost all the offices.
I agree with you. I agree with you that a lot of people have raised eyebrows. But if we're looking at who can work, who can perform, then we need to look beyond that and allow the best to emerge. As I've said, the convention at this point in time, as far as I know, is that in respect of the presidency, we allow it to go round. The other posts are open to everyone. Obviously, when you are trying to canvass for support, you then find out that this horse trading goes on in terms of inclusiveness. And so you find out that you have maybe your vice presidents may come from different parts of the country. But all this is a gentleman's discussion. It's nothing that we should elevate to constitutional importance. So I'm not particularly disturbed that the Eastern Bar Forum have got all the candidates. Probably the other fora didn't work hard enough to sell their own candidates as being better for the job. It's not a question of the Eastern Bar have more delegates.
Now I want you to assess the last administration. How well would you say they've performed in terms of the profession and the larger society, and then set an agenda for the incoming administration? What are the things that you would like to see them achieve in their 2 years or so that they would stay in office?
I think every president has come with his own agenda. And I think that the last few presidents, their agendas have been focused on civil society, upholding the rule of law, to the detriment of the profession, because the association has an obligation to the profession as well. This outgoing executive have also focused to an extent on the role of the lawyer as a social engineer, sometimes to the point where we're actually perceived as an opposition party. I think that's what they have done. I think there's been a fair amount of discontent because with the economic crisis, lawyers have also been affected in terms of the ability to get employment for young lawyers, in terms of the ability of large firms to sustain the lawyers that they employ. And so everybody's suddenly saying, I have a profession, what are they doing for me? What's my association doing for me? And I think those are the tensions that may have impacted upon this outgoing administration.
So if you were to rate them on a scale of 1 to 10?
5.
5, so average.
Yes. There's a lot that the MBA should be doing. And we've concentrated on the civil society side. We now need to concentrate on the profession. And if I'm setting an agenda for the incoming president and going by his campaign promises and the things he's talked about, I think he's going to focus his attention equally, both on civil society, democracy, upholding the rule of law, and on ensuring that the legal profession is properly taken care of and that we have a future for the younger lawyers who are coming into it.
In terms of setting an agenda, when I asked some of your colleagues at the conference to set an agenda, one of them also talked about appointments of judges, that the NBA should be more interested in how judges are appointed. It shouldn't just be promotion from one stage to the next, but it should be maybe elevation. I don't know. What are your thoughts about that?
No, I agree with that. I think that over the last 3 administrations, I think the NBA has been consistent on that view, that appointment of judges to the higher courts should not be on the question of promotion. But I think there's a larger picture. If the profession ensured that lawyers are properly trained, properly qualified, are conversant with modern practices, It doesn't matter where the judge is coming from, whether he's coming from the bar or the bench, he would still be a good judge on the appellate court. I think the problem is because there's a sense that at the appellate level, maybe we're not getting what we expect. That's why there's this agitation for it shouldn't be promotion. We should be able to look anywhere and get good judges. But if you look outside the lower bench and you are looking at the profession, and the profession itself has not assisted the lawyers to be conversant with the modern day law, you're just swapping bad for bad.
To do that, to appoint from anywhere in the profession outside of the bench, wouldn't that require like a constitutional amendment or something?
I don't think it does require any constitutional amendment. I haven't seen anywhere in the Constitution that says judges of the Court of Appeal must have served on the High Court. And I don't see anywhere in the Constitution that says a Supreme Court judge must have served in the Court of Appeal.
So it's just a matter of practice
It's a matter of practice and convention. There's a lot of noise now about the fact that they say a governor of one state wants to bring a judge from another state to be his chief judge. And of course, those within the judiciary in that state are not happy about it because they see themselves as being superseded in terms of promotion. But constitutionally, there's nothing that stops the governor from doing so. So I think we need to start looking at what's best for the profession as opposed to what's best for individuals.
Now, this is another question that a lot of people have, wanted to find out from some lawyers. Before the National Assembly embarked on its annual vacation, they threatened to impeach the president if he fails to implement the budget in full. In your view, do you think that this is an impeachable offense?
I don't think it's an impeachable offense. I'd like to see how it's going to be phrased. But then you have to remember that the legislators have, if they can muster the 2/3 majority. But the point that I'd even like to make is slightly different. The budget is just an estimate of how much money the government intends to spend in a particular year on particular items. So the question of implementing to the letter, you can't spend what you don't have. And I see this pressure of implementing the budget. You must put money in the economy. You need to give the executive the flexibility to say, we brought this plan to the table, you've approved it. But in the middle of the year, something else has happened, and it's become more important to put more money in a different area. If it means increasing one part of the budget, you go and ask for supplementary budget. If it doesn't increase the amount, you just don't put so much money in an area you've budgeted for. So I don't personally see a budget as you must spend the money. It's merely an indication of what you'd like to do with the money you've got. I don't see it as being impeachable.
But in any case, whether it is impeachable or not, because they have 2/3 majority, they can't get away with it.
We've seen some states in the past where the houses of assembly went and sat in hotels and allegedly impeached the governor, and they were able to get away with it until they went to where they needed to go, which is the courts. The courts then looked at the constitution, looked at the procedures, and said, sorry, you haven't got away with it. So Nigeria is a country where...
Perhaps the proper procedure should then be that if the National Assembly members think that implementing it fully is the proper way to go, they should test it in court rather than try to impeach. Okay, we've also heard from the grapevine that when the presidency is zoned to the southwest again in another 2 years, that you'll be running for office of the president of the NBA. Can you confirm this?
Yes, 2014, by virtue of the convention that has come into place, the next presidency comes to the southwest. And God willing, and God giving me life, I intend to I have thrown my hat into the ring, and I will be putting myself forward again. And hopefully I'll have better luck than 2006.
So what is the criteria that you want your colleagues to be judging you on?
One, I want to be judged on my record. I've worked in various capacities in the NBA, whether as an officer or a not officer, and I've always performed. And I've always got the commendation of people, whatever assignment I've been given to do. What I'd like us to do, if God wills, is for us to focus on how we can be a profession that can cater for its members. We're falling behind. We're falling behind the rest of the world. We're getting to a point where young lawyers study law and you see them on Okada. or you see them hanging around, their take-home pay doesn't take them home. And the profession needs to create the market for lawyers. That's what the bar associations do. And that's what we are not yet doing. We need to make lawyers understand, we need to make everyone else understand that whether you're a market woman, a driver, a trader, you need a lawyer. And that's how we get employment.
And that is all we can take on this episode of the program. Please feel free, as always, to send in your questions or comments via Facebook, email, or Twitter. I am Shola Soyele. Thank you for watching.